Hi, my name is Pam Hedrick, and for this assignment I chose to do the 3 equal employment opportunity laws and describe why they are important. Those 3 are Title VII, Age Discrimination Employment Act, and Equal Pay Act. According to the JFK Library, President John F. Kennedy was going to sign the Title VII for Civil Rights Act before he died. However, President Lyndon Johnson signed the act on July 2nd, 1964. The act outlawed segregation in businesses such as theaters, restaurants, and hotels. It banned discriminatory practices in employment and ended segregation in public places. Once the law was signed, the president established equal employment opportunity. The EEOC is responsible for enforcing federal laws, and with that, and they affect all 3 of the protected classes, Title VII and Title VII. Most employers with at least 15 employees are covered by EEOC laws, as well as 20 employees in age discrimination cases. Most labor unions and employment agencies are also covered. The laws apply to all types of work situations, such as hiring, firing, promotions, harassments, training, wages, and benefits, according to the EEOC website. With that, I will discuss the 3 laws given. The 3 laws give examples and explain why they're important. First of all, the Title VII of the Civil Rights Act of 1964 makes it illegal to discriminate against someone on basis of race, color, religion, national origin, or sex. The law also makes it illegal to retaliate against a person because the person complained about discrimination, filed a charge of discrimination, or participated in employment discrimination investigation or lawsuit. The law also requires that employers reasonably accommodate applicants and employees sincerely held religious practices, unless doing so would impose an undue hardship on the operation of the employer's business. Title VII also includes the Pregnancy Discrimination Act. This law was amended to Title VII to make it illegal to discriminate against women because of pregnancy, childbirth, or medical conditions related to pregnancy or childbirth. This also includes the retaliatory discharge. One example of Title VII, was EEOC versus McKesson Water Products. And this lawsuit actually was approved through the federal court of $1,245,000 in 1998 to Stephen Crutchfield and several other African American employees, which they filed charges of discrimination with the commission, alleging that they had suffered racial discrimination at their drinking water processing and delivery company. The EEOC charged that McKesson had paid African American drivers less and increased their compensation at a slower rate than white drivers. They claimed that McKesson assigned African American drivers to routes in low-income neighborhoods, which were often less profitable than the routes in affluent companies or communities. Because the pay and promotion were tied to the profitability of the routes, the African American drivers received lower compensation and fewer promotions than those assigned to the affluent areas, which is, and this is also on the EEOC website. The Age Discrimination in Employment Act, which is ADEA, this was put in law in 1967, which protects people who are 40 or older from discrimination because of age. And my example that I found on the EEO website also was EEOC versus Marymount Manhattan College. The commission alleged that the charging party, a 64-year-old choreographer instructor, was not hired for an assistant professorship in dance composition because of her age in violation of the ADEA. The defendant, a private liberal arts college, initially selected the 64-year-old choreographer instructor and the other 2 applicants as finalists. However, after determined that the 64-year-old was the leading candidate, defendant expanded its search to include a less qualified 37-year-old applicant as the fourth finalist because it considered her to be at the right moment of her life for commitment for a full-time position, which is unreasonable. The next one I have is Equal Pay Act of 1963, which forbids wage discrimination on the basis of gender if employees perform equal work in the same establishment. Jobs are considered equal if they required equal skill, effort, and responsibility, and are performed under similar working conditions. Differences in pay between men and women doing equal work are legal if the differences are based on any one of the four criteria, which called affirmative defense, which is seniority, merit or quality of performance, quality or quantity of production, some factor other than sex. These terms for comparison are permitted defenses seemingly deceptively simple, but yet numerous court cases have been required to clarify the Act's provision, particularly in the definition of equal, which is from Newman 2017. Here's an example of the Equal Pay Act is EEOC versus Sturman College of Law. The EEOC lawsuit that charged the university violated the federal law by paying a class of full female professors at Sturm College of Law lower salaries than they paid their male counterparts who were performing substantial equal work underneath this under similar working conditions. According to the EEOC, in October of 2013, salaries of female full professors were on an average of $19,781 less than the male full professors, and all the women's salaries were below the average salary paid to the men. Despite formally recognizing the significant pay disparity in a memo in 2013, the university declined to take corrective action and adjust the salaries of the full female professors, and that was also according to the EEOC. The second one I thought was very important because the Lilly Ledbetter Pay Act there was several different places on the EEO website and in the Newman 2000 edition. They claim that the Lilly Ledbetter Pay Act was made after she left her job as a supervisor in a tire plant and was based on lasting effects of compensation decisions she allowed to be discriminatory that were made as such as 19 years earlier, far outside the 190-day period. In 2007, the Supreme Court ruled Ledbetter versus Goodyear Tire and Rubber Company that decisions could not be litigated because they were outside the statute of limitations. However, in 2009, an act, which was signed by President Obama, overturned this rule. Instead of stating that discrimination acts occurred, the starts is 180 days, now 300-day time after filing a claim. Each time a discriminatory paycheck is issued, not just when the employer makes an adverse pay setting decision, which is in Newman 2007. So all of these laws are important because of equal employment opportunities. Employees cannot be treated fairly or equal. According to the EEOC website, it also shows statistics in 2017 that there were 84,254 total charges were made by employees. 18,376 were age discrimination charges, 996 for Equal Pay Act, and 69,108 for color, race, and national origin, sex, and religion charges, according to the EEOC website also. These laws try to make it equal so that certain classes of people who have been discriminated against are not retaliated against. These laws help help to create certain discriminatory practices illegal, including discrimination based on race, color, religion, sex, and national origin. These laws ensure that all employees or job applicants have equal opportunity to engage in the employment market and are not subjected to adverse treatment based upon certain characteristics that have nothing to do with being a qualified job applicant or employee. Thank you, and if you have any questions, you can put it on the group board that we have to do. Thank you.